there are lawyers. Then there is a champion for justice, Attorney Stephen Stubbs.
Stephen Stubbs fights for justice every day. Stephen Stubbs.
Welcome. I'm glad that it's a packed house today. We're here at the Leatherneck Club in Las Vegas, Nevada, a place that has defended our rights on multiple occasions. It's a Marine Corps facility, and I'm a son of a retired Marine, and so I'm proud to have this Know Your Rights seminar, police encounters, here at the Marine Corps League and the Leatherneck Club. So thank you, and thank you all for coming. We are Facebook Living this, as well as recording it. We'll post it on YouTube later. There's been some things going on that I'm not too happy about. Since the year 2010, I've been dealing with police and internal affairs about what police are allowed to do and aren't allowed to do. And about 3 years ago, I thought we kind of had things settled, and things did settle down. But this last weekend, some things happened here in Las Vegas that are very concerning. So today, I'm going to go over the laws. I'm going to talk Supreme Court cases. I'm going to talk United States Supreme Court cases and Nevada Supreme Court cases. I'm going to talk statutes. This will be chapter and verse. And I hope that police officers watch this, because they took an oath to support and defend our Constitution. And unfortunately, there's some police officers that want to get away with whatever they can. And so they have that attitude instead of the attitude that, hey, we have a Constitution, we're Americans, and that Constitution should protect us. So today we are going to talk about those rights. A couple housekeeping matters. Please turn off your cell phones. Also, this presentation is Nevada law. I am a Nevada attorney. I am not licensed anywhere else. There are parts of this that are federal that would go to other states. However, Nevada also has some special protections, because states are allowed to give more protections than the Constitution. However, they're not allowed to give less protections. Nevada is one of those states that has given some more protections. It's a beautiful thing. When our Nevada Constitution and our statutes protect us more against our government instead of less. So please, if you're in another state, watch this, ask a local attorney. Look at things in your state, because if you're in Nevada, even if you're visiting Nevada, this is the law. If you are on probation or a parolee, don't use any of this stuff. You are on a contract with the state to where you are not in prison. In exchange for you not being in prison, you waive all kinds of rights. So please, yes sir, is all you need to say, because you do not have constitutional rights, because you waive them so that you're not in prison. That's the way it works. This is important. It's a big warning I'm putting at the beginning. There's a price to pay when you stand up for your constitutional rights. There is a serious price to pay. If you do not know, and if you are not correct, if you do not know the law and you refuse a lawful order, you are guilty of obstruction, and you can go to jail in Nevada for up to 6 months. Okay. You must know your rights before you exercise them. It's very, very serious. Okay. Don't pretend to know them. Don't think you know them. Do whatever the officer says unless you know otherwise, because it's very, very, very serious. Now, you could even be right and the officer could be wrong, and you could still get arrested for obstruction, and you could still go to court over it. You'll have to fight, okay? Even if you're right and even if they're wrong. That's just a reality of life. And it happens. It's happened to me. It's happened to a number of my friends. And we fight and we take care of things. But you've got to know that there is a price to pay for exercising your rights. If you're not willing to pay it, then waive them. Right? That price to pay is knowledge. You have to know them, and you've got to be willing to stand up. And you have to be right. And I'm so sad for people who, in good faith, try to do things and they're wrong. So sad for them. But that's the law, and there's no good faith exception to that. So that's just the way it is. By the way, if police officers make a mistake, they still go home to their families. Nothing really happens. They might go to internal affairs and have to get new training. But on the other end, it's not exactly the same thing. But warning, you have to know your rights. You have to know the law. And if you don't, I wouldn't play this game. I just wouldn't, okay? Know what you're going to do, okay? Police can lie to you. Guess who said that? The United States Supreme Court. In Fraser v. Cupp, police are allowed to lie to you. They are allowed to tell you false things. They are allowed to tell you false things about the law. They're allowed to make up laws that don't exist. They're allowed to do all these conniving things if they wish to try to get you to do what they want you to do. It is 100% constitutional. I don't particularly agree with this, but that's the law. And we have to deal with the law, and we have to deal what the United States Supreme Court has said since 1969. So just know that. The police can lie to you. However, you can never lie to the police, not even once. That is a crime punishable in the state of Nevada up to 6 months in jail. So police can lie to you all they want, which is why you need to know the law, because they can very forcefully tell you things that aren't true. Police can lie to you. You cannot lie to police. Don't do it. It's against the law. Today's agenda, we're going to go over filming police, constitutional police encounters, what they are allowed to do under the Constitution, illegal seizures under the Fourth Amendment, Nevada's 60-minute rule, Nevada's duty to identify statute, police illegally threatening businesses, that's happening, and then also how to properly handle a general police encounter and also a traffic stop. That's today's agenda. Again, we are going to be talking laws. We're going to be talking Supreme Court cases, both Nevada and United States Supreme Court cases, and we are also going to be talking about the statutes. This is something you can take to the bank, you can look up, you can watch this later. I'm giving you citations. Filming police. In the state of Nevada, you have a First Amendment freedom of press right to film police. Freedom of press right. Now, that started in 1995 in the Ninth Circuit. They made a very general ruling, but that's the way it was. Then in some other circuits, they made some rulings finally in 2012. ACLU of Illinois, they won a case that even went up to the United States Supreme Court, and they denied cert. Okay, what does that mean? That means the Supreme Court looked at the result of the case and said, do you know what? We're going to let that one stand. That's great news. However, it's not binding on the other states. So there is clear law established in the First Circuit, the Seventh Circuit, the Ninth Circuit, and the 11th Circuit. 19 total states. I'm going to read these off. Nevada, Montana, Idaho, Oregon, California, Alaska, Hawaii, Arizona, Alabama, Georgia, Florida, Illinois, Indiana, Wisconsin, Maine, New Hampshire, Massachusetts, and Rhode Island. There is clear law established, binding authority in all of those states through the circuits, that you have a First Amendment constitutional freedom of press right to film police if they are in public performing their official duties. That is the law. That's the way it is. There is one judge at the lowest federal courts in Pennsylvania that decided to say you don't have that right. That's been appealed by the ACLU. We'll see what happens there. The other jurisdictions generally accept what's going on. This is generally accepted. And so you should be safe in the others. However, it's not binding authority. But you can film police, two things. In public, performing their official duties. That is your right. Okay? In every police encounter, the first thing you should do is you should start filming. This is very dear to me because I was representing a client once, right actually here in front of the Leatherneck. I was representing a client. He was being questioned by police, and gang task force showed up. Sergeant Utomi showed up, and she ordered me to leave so that she could question my client without me there. I refused. She arrested me. And I thought, you know what? The truth will come out. Everything will be great. My stomach dropped when I read the police report that was submitted to the district attorney because it was all fiction. It was fiction. And if it were true, I would be guilty and I would likely lose my law license. I cannot explain what that feels like when a police officer lies in an official report and it's against you And actually, she actually wrote 2 reports. We found out later she wrote a more truthful report, and then the report she submitted to the DA, even though the DA asked for all reports, she pocketed the other one that was truth of what happened. She pocketed it, and she let the trial go on. Luckily, a friend of mine pulled out his cell phone, and he videotaped, and he caught it. You can watch it if you want. Go to YouTube and search Stephen Stubbs arrested, and you'll see it, and it's there. I am so grateful to him, and I will always be grateful to him, simply because he pulled out a cell phone and he videotaped it. Because that videotape was shown in court during the prosecution's case, and Judge Eric Goodman, right after the prosecution closed their case, said, this is ridiculous. You're not guilty, Mr. Stubbs. You don't even have to put on a defense. And I am so grateful that it was videotaped. Videotape is something to where it can't lie. It's a perspective, right? It's not always all, right? But you know it's not lying to you, right? Video is so important anytime that you have any kind of case against the police. So please, the very first thing you should do whenever you encounter the police is to start filming. Film your buddies. If your buddy is talking to police, film them. And film the person that's filming. We recently had a case where someone was filming and the police came up to them and the police arrested them, and the police said some things, and we didn't have anybody filming them. So we didn't have any evidence, some hard evidence that said he was not doing. There were lots of people around, and so if you see someone filming and you know they got that shot, film them. Step back. You can film the police and film them at the same time. That's a way to protect yourself, and it is 100% protected under the First Amendment freedom of press right in the state of Nevada, and also in those circuits, and most of the United States will support that. Constitutional police encounters. What are police allowed to do? There's a couple standards, and depending on the standard, they can do different things. There's reasonable suspicion, and there's probable cause. They have different powers depending on what standard they have. So we're going to talk about those standards. Okay? Reasonable suspicion. This is the standard to detain. If a police officer has reasonable suspicion that you have committed a crime, are now committing a crime, or are about to commit a crime, they can detain you to figure some stuff out. 100% constitutional. That's the way it's supposed to be. It has to be more than a hunch. They have to be able to give specific and articulable facts. That's what the case law says, which means they have to be able to say, do you know what? I saw this, I saw that. And they have to be able to articulate those facts. Okay? If they have that, they are allowed to detain you. And in the state of Nevada, where we have extra protection under NRS 171123, they are only allowed to detain you for a reasonable amount of time to effectuate the purpose of the stop, not to exceed 60 minutes. But only a reasonable amount of time is what you have in Nevada. Not all states have that. Nevada is special, and I'm grateful for it. But they can detain you for a reasonable amount of time to figure some stuff out. Probable cause is a higher standard. That's a reasonable belief standard, right? Most people say, you probably did it. The Supreme Court said that there has to be slight or marginal evidence in the state of Nevada. But if they have probable cause, that is the standard for both a search warrant and an arrest. It's stronger than reasonable suspicion. It's not as strong as beyond a reasonable doubt. And again, law enforcement needs to be able to articulate specific facts of what's going on in order to have that standard. They need to put it in an affidavit for a search warrant, and also an affidavit if they arrest you. They need to be able to articulate those facts. So those are the two standards. Now, what can they legally do in a traffic stop? Okay? Because traffic stops, they're their own little thing. Okay? Number one, they get to demand your license, registration, and insurance. If you do not provide that for them, you are committing a crime, and you can be arrested, and you can go to jail for up to 6 months. Even if your stuff is good, if you don't have it on you, that is a crime. And you can fight it later, and you can get it dismissed. I do that all the time. However, have all your stuff and have it ready. because they are allowed to demand your license, registration, and insurance, and you must give it to them, okay? They're allowed to ask questions. That is 100% constitutional. However, you don't have to answer. That's also 100% constitutional. If they are afraid of you, they are also allowed to have you and everybody in the car get out of the vehicle, and then they can search both you, they can pat you down for weapons, and they can search, they call it your wingspan. It's the entire inside of the car, but not the trunk. And it's for their safety, and the Supreme Court has carved out that exception for officer safety. So if they are afraid of anyone in your car, they are allowed to do that. They can tell you to get off your bike. They can do that. They can even make you sit down on the sidewalk. That is 100% legal and 100% constitutional. And at a traffic stop, they are allowed to detain you for a reasonable amount of time to effectuate the purpose of the stop. That is a traffic stop, right? Reasonable amount of time. Different courts have thrown out some numbers. The Second Circuit says it's 9 minutes. Another circuit said it's 20 minutes. It just has to be reasonable, okay? If they try to extend that, then it's not really reasonable, right? If they're asking you other questions. But as long as the officer is just pulling you over and is just doing a regular, ordinary traffic stop, that is 100% constitutional. Please don't tell people that it is unconstitutional for traffic stops, because that is just not true. Okay. If you choose to talk to them, if you choose to answer their questions, you are voluntarily extending that time. That you can do that. You're consenting. That is also constitutional, and you can't come back later and say, oh, this lasted 27 minutes, oh, they violated my rights. No. If you want it to be as short as possible, you just politely don't answer their questions. Because if you begin and you start answering their questions and you want to have a conversation, that is consensual. Even if you don't want to be there, it's consensual, and you're extending the time. Now, illegal seizures under the Fourth Amendment. There's a very, very important 2005 case, Torres v. State of Nevada. It's an Elko case. And there was a guy who looked pretty young. And he had an alcoholic beverage in his hand. And he was walking down the street. And a police officer saw him, saw he looked young. Did he have reasonable suspicion? Yes. He can specifically articulate, you look young, you got alcohol in your hand. So he detained him and said, you look young, you have alcohol in your hand. The gentleman produced an ID that proved that he was at least 21. Now, that officer then said, thank you, just a second, and he did a warrants check. After the reasonable suspicion was already gone. And the Nevada Supreme Court case said very clearly, no. You cannot do that. You can't hold on to someone's ID that long. You can't detain them longer after there's no reasonable suspicion. What happened? They did a warrants check. They found out that he had warrants in California, so they arrested him. Then they found out that he had a gun, and he was a felon with a gun, and so they were prosecuting him for all kinds of crimes. All that evidence was thrown out because the Nevada Supreme Court said that violated his Fourth Amendment rights. Right? That was a violation. How can we apply this to us? If you are detained and there is no reasonable suspicion, that is a violation of your rights. If you are detained, say for traffic, and then they decide that they are going to hold on to your driver's license so you can't really leave, so that they can ask you questions about stuff that has nothing to do with traffic, that is a Fourth Amendment violation pursuant to Torres v. State of Nevada. They are violating your constitutional rights. In fact, the Supreme Court suggests that as soon as the reasonable suspicion is satisfied or the stop is over, they have to immediately give you back your paperwork. They cannot hold on to it. That is Torres. That is a Nevada Supreme Court case, and I would challenge any police officer to show me otherwise, because it just ain't so. In Nevada, that's the law. That is not necessarily true in other states, but in Nevada, that is the law. 60-minute rule. This has been one of the most understood or misunderstood laws with police officers for a very, very long time. Because so many police officers say, I can detain you for 60 minutes. No, that's not what the law says. The law says a reasonable amount of time to effectuate the purpose of the stop, not to exceed 60 minutes. It's the 60-minute ceiling, right? Once 60 minutes is there, if they're not arresting you, they got to let you go, right? But a reasonable amount of time. I, since 2010, have been barking up this tree, talking to Internal Affairs. Finally, in April 2014, Internal Affairs sends out a bulletin, an integrity bulletin, putting every police officer on notice. This is the law. You can only detain them for a reasonable amount of time to effectuate the purpose of the stop, not to exceed 60 minutes. Everybody was put on notice. Torres came out. Nevada Supreme Court says, yeah, that's it. That's the law. But for some reason, police have either forgotten or they're ignoring it. Because just last weekend, I heard of multiple cases to where they're pulled over for traffic and then they want to question, and they happen to be pulled over by criminal intelligence. Does criminal intelligence regularly do traffic stops? The answer is no. Their job is to gain intelligence. What do? They use traffic stops to try to get intelligence. Guess what? They got a very small window, enough to do that traffic stop. After that, if they hold you longer than that, they are violating your Fourth Amendment rights pursuant to NRS 171123, Torres v. Nevada, and the Las Vegas Metropolitan Police Department, Internal Affairs. Everybody agrees. They are put on notice. They know this. Excuse me. Now, I already covered this. Okay, so after a police officer is done, they must give you back your paperwork. They cannot extend the detention, and the officer can only detain you for a reasonable amount of time to effectuate the purpose of the stop. Torres v. State of Nevada, NRS 171123. Okay. Police cannot access your phone without a warrant. Since 2015, United States Supreme Court case. This is good throughout all of the United States, right? However, they will try to get you to consent. They might even lie to you. They might threaten you with arrest. They might do all kinds of things. However, without a warrant, they cannot go into your phone. That is the law. Again, they try to get you to consent. They don't have to be truthful, and they might threaten you.
What if
We're not doing questions till the end. Thank you. Nevada's duty to identify statute. Do you have to give your ID to an officer? Your physical ID? Okay? The answer is only if you are driving a vehicle. If you are driving a vehicle, you must surrender your driver's license upon demand. That's NRS 483350. Okay? The passenger, however, is not covered under that statute. The passenger does not have to give ID. The other exception is if you have a CCW. There's a statute that says that if you have a CCW and you are carrying concealed, two things. Then you must give them your CCW, and you must also, well, upon request, you must give them your CCW, and you must also give them your ID. There are some legal arguments that since the CCW itself is a state-issued ID, that it covers both. Just don't mess with it. There's legal arguments. We can argue about it on Facebook and all over the place. Great. We can argue. Just give them your ID too. Just do it. Right? They already have your ID. What's another one? It just doesn't matter. Okay? Those are the only times in the state of Nevada that you are required to give your physical identification. I challenge any Metro officer. If you can prove me wrong, I will Facebook Live, let you taser me in the rear end. That is a challenge because this is true. Those are the only two exceptions. Okay? The only two. However, Nevada does have a duty to identify statute. Guess what? The United States Supreme Court interpreted that statute. In the year 2004, they brought up a case to the U.S. Supreme Court, and it said very, 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 very clearly, if there is reasonable suspicion You must give your ID. You must identify yourself, not give your ID. Identify yourself. However, that means you only have to give your legal name. It is in your best interest to give your legal name, because if you lie, it's a crime. Also, if there's lots of other people, you need to give your middle name or something, because if there's a warrant under that legal name and the person happens to be your age and build, you're going to have a problem. Under those circumstances, maybe you even want to give them your social security number if they ask, or your birth date, to make sure that you're not cut up with somebody that happens to have the same age and look like you and have the same name, because that is probable cause for an arrest. However, you do not have to give that ID. Interestingly, if you're a passenger in a car and they stop for traffic, is there reasonable suspicion that you committed a crime, or is it the driver? Unless they have specific, separate, reasonable suspicion that you committed the crime, or that you were about to commit the crime, or that you had committed a crime. Unless they have that, you don't even have to identify yourself. The United States Supreme Court has interpreted the statute. You don't have to. You don't have to even give your name. You don't have to do anything. You ask them if you are specifically being detained, and if you are specifically being detained, you have to give your legal name. Ooh. Police, they were doing some things some years ago, and we talked to Internal Affairs, and we talked to them, and they stopped. They've started up again. Burgess v. Story County is a very important Nevada Supreme Court case, extremely important. It's a case where there was a brothel in Story County, and there was a motorcycle club that would frequent that brothel, and the police didn't like that. So what did they do? They had the Board of Commissioners of Story County threaten their brothel license, their privileged license, and say, if you allow this motorcycle club into your brothel, we're going to take away your liquor license. The owner of the brothel said, it's my First Amendment right, I'm allowed to do this. They took away his liquor license, and so he sued. And it went all the way up to the Nevada Supreme Court, and the Nevada Supreme Court said, that is a First Amendment violation. Police are not allowed to do that. Okay? So what's happening now? Just this week, police have started going to bars and telling them, if you let certain motorcycle clubs, certain people into your bars, we're going to revoke your liquor license. 100% illegal, 100% unconstitutional. They just don't care, or they don't know. But I doubt they don't know, because we've talked about it so much. They either don't know or don't care, and they are violating the First Amendment rights of the bar, and they are violating the First Amendment rights of those patrons that the bar owners want in their establishment. The government doesn't get to choose who gets to do business with you. That's what this case says. If you are a facility, a business, and this happens to you, I will represent you for free, gratis, pro bono. I'll be glad to do it. The case law is soundly on our side, and I will stand up with you. I will do that. This is a very important case, and they are trampling on our First Amendment rights, and it's just wrong. Okay, so how do you handle general police encounters? Number one, first thing you do, you take out your phone and you film. You film the encounter. Okay. Number two, just be polite. There's no reason to escalate a situation. We want to de-escalate the situation. Be polite. There is no reason not to. And if they're escalating the situation, still be polite. There is nothing good that can happen from you escalating that situation. Ask, am I being detained? Okay. If the answer is no, you can leave. Guess what? If you stay, it's a consensual encounter, and you just waived that constitutional right. Let me say that again. If they say you're not being detained, they say no after you ask the question, and you stay, you have just waived that constitutional right. It is a consensual encounter. They get to talk to you. That's just the way it is. Okay? If they say yes, ask them why. Do you know what? They don't even have to answer. Right? They should, And they do sometimes. But you know what? You don't have to answer their questions either. So you can insist on knowing why before anything else happens. You can do that, right? Right. But ask them why. Then you want to invoke your rights. You just simply say, I don't answer any questions. That's your Fifth Amendment right. You don't have to answer any questions. I do not consent to a search of any kind. And I want my attorney here. If you are being detained, if you are not free to leave, and they are asking questions, you have a Fifth Amendment right to an attorney. That's just the way it is. If they continue to ask you questions, just invoke again. Invoke your right. And if you get tired, do what I do. Exercise your First Amendment right to sing them a song. There's a couple YouTube videos and Facebook videos to where I simply say, officer, I am invoking my Fifth Amendment right not to answer questions and my First Amendment right to sing you a song. Why? Because I don't want to talk to him anymore, right? And I started writing a musical about this very subject, so you guys are going to get to hear my musical. Just one second. Every time I get pulled over might be just fine, or a chance to flex my rights. If you're asking questions and I'm not free to go, I say, I want my lawyer, please. I won't answer inquiries. Searches aren't an option, man. I won't consent, no. I record everything. If we're done here, I'd like to leave. I flex my rights. I flex my rights. If you are a police officer and you keep asking me questions after I've invoked my rights, you're going to have to sit through that as many times as is necessary before you stop. That's just the way it is. All right. Thank you. My daughter asked me not to do that, but sorry, honey. Okay. How to properly handle a traffic stop. This is just a little bit different, Again, film the encounter. Be polite. Please be polite. Give the officer your driver's license, your proof of insurance, and your proof of registration. If you forgot them, don't have them in the car, they aren't current, they can arrest you for that. Just give it to them, right? If you don't have it, then you might be sunk. That's just the way it is, okay? If they ask you any questions, just simply tell them, I don't answer questions. I don't. And you can also tell them, I don't consent to a search of any kind. Now, there's a U.S. Supreme Court case, Berkemer, for this next part, which is very, very important. Because in an ordinary traffic stop, a regular ordinary traffic stop, you don't have a Fifth Amendment right to counsel. You don't. However, if that traffic stop goes outside of ordinary traffic stops, then you do. And if they ask you any questions outside of something that would normally be asked or is normally part of a traffic stop, if they ask you any of those questions, then you can invoke your Fifth Amendment right to counsel. So if it's just a traffic stop, just let it happen. It's fine. But if they ask you, say, if you're a biker and they ask you about your patch, they're questioning you about what's in your car, anything else like that, you can invoke your Fifth Amendment right to counsel. Okay. If they, and if you do invoke, just tell them your lawyer's name and the phone number, okay? You could say, if you want, my lawyer is Stephen Stubbs. His phone number is 702-759-3224. That is my cell number. If you are in that situation, you are welcome to use it. Please use it. That's the best way to do it. And I would like to be your attorney, so that's nice, right? If they continue to ask you questions, you can invoke your rights as many times as you want. And if they won't stop, feel free to simply invoke your rights and then say, I am also going to invoke my First Amendment right to sing you a song. Maybe you want a religious song. Maybe you want a Mormon religious song. That'll make them go away real quick. If you grow up Mormon, you're in a good spot, right? I'm a Mormon, so I can say that. I can do that. But that's how traffic stops are supposed to be handled. That's how you can handle a traffic stop. So I went through today's agenda, right? Did I cover filming police? Did I do that well? Okay. Constitutional police encounters, what police are allowed to do under the Constitution. Illegal seizures under the Fourth Amendment. Nevada's 60-minute rule. Nevada's duty to identify statute. Police illegally threatening businesses. Again, if you are a business and this happens to you, if they threaten your liquor license or your privileged license and they tell you that you're not allowed to have certain people at your establishment, please call me. I will represent you for free, pro bono, gratis. You won't owe me a dime, not a single dime. Okay. How to properly handle general police encounters and how to properly handle traffic stops. That's what I said I would do, and I've done it. Again, warning. This is so important, so important. There is a price to pay when you stand up for your rights. There is a price to pay. You're not even sure the police officer is going to write an honest report. That happened to me. Right? Film everything, absolutely everything for your protection. There is a price to pay, and you better know your law. You better know your Constitution. And if you go to a different state than Nevada, you better know their laws and how it applies to the Constitution, because there are subtle and little differences. You better know it, because if you are wrong, you can get a criminal record, you can go to jail, and it will be 100% legal. Right? And even if you're right and the police officer is wrong, they can still arrest you. They can still arrest you, and if it's a good faith mistake, you can't even sue them, right? If it's not a good faith mistake, they've got insurance to cover it, and they don't have to pay it even if you do sue them. That's the way it works. They will still go home to their families. It's no skin off their neck. They will still go home to their families. There is a price to pay, and you have to be willing to pay that price. And the first part of that is knowledge. Know the law. Know what it is. And then, if you're going to stand up, be prepared. Be prepared. Now, I'd like to answer any questions that you have. Yes, Rich?
Do they have a right to go and search your saddlebags out of stock?
Okay. Going back to, the question is, can they search your saddlebags in a stop? Going back to the Fourth Amendment seizures and what's legal and not legal, in a traffic stop, if they are afraid of you, they are allowed to ask you to get off your motorcycle, and they're allowed to pat you down, and they're allowed to search that motorcycle for weapons, but not if your saddlebags are locked. If your saddlebags are locked, that's akin to a trunk that is not in your wingspan, and so they cannot. However, if your saddlebags are not locked, yes, they get to go through and search that all they want. But again, that's only if they're afraid of you.
Steven Stubbs.